Hello everyone, my name is Nikhil Mogha. Welcome back to the channel. In this video, we will discuss the procedure for transmission of shares under Companies Act 2013. Section 56 of the Companies Act 2013 talks about transmission of shares. It is a form of transfer whereby the shares are transferred by operation of law. The word transmission can be construed as the transfer of title, whereas the word operation of law is a way whereby someone gets certain rights automatically under the law without taking any action. For instance, if a person dies without a will, their heirs are determined by the operation of law. Now, we will discuss what is transmission of shares under Section 56. The subsection 2 of Section 56 of the Companies Act 2013 provides for the transmission of shares. It states that a company is obliged to transmit the shares by operation of law on receiving an intimation by the claimant. Further, the company under subsection 4 shall deliver all the certificates of the securities to the claimant within 30 days, provided that they are not prohibited by provision of law, any order of the court or tribunal, or any other authority. Now, we will discuss under which section the company can refuse for registration. According to Section 58 of the Companies Act 2013, a private company limited by shares can refuse to transmit the shares in the name of the concerned person in pursuance of any power of the company under its article of association. The company refusing the transmission shall give the notice to the person concerned within 30 days from the date of receiving the intimation for transmission, and the said notice shall include all the reasons dictating the conditions for such refusal. However, the claimant has the right to appeal in the tribunal against the refusal within 30 days from the date of receipt of the notice. In case the person does not hear from the company within 60 days from the date of intimation or transfer to the company, then he can appeal within 60 days from the date of such intimation. Now, we will discuss what are the relevant provisions under Schedule F of Companies Act 2013. The relevant provisions under the schedule are: the first one is eligible persons. The schedule states that the persons eligible to apply for the transmission of shares on the death of the member are survivor, if the shares are held jointly, nominee or nominees, legal representatives. The second is election of person. Any person becoming entitled to the shares can elect himself as the holder of the share or make transfer of share as the member has made when he was alive. The third is delivery of documents. After becoming entitled to the share, a person shall have to deliver all the documents to the company as may be provided from time to time. The fourth is entitlement for dividends. The person who becomes entitled to share because of transmission occupies the right to receive the dividends. Along with the dividends, he also acquires all the rights attached to the shares. Now, we will discuss what is the procedure for transmission of shares. The claimant of the shares shall, in the prescribed format, make an application to the issuer company for the transmission of shares. After examining the documents, the issuer company executes the transmission by issuing a letter of confirmation. After issuing the letter of confirmation, the documents are submitted with the registrar and transfer agent, who will retain the physical shares and stamp on the copy of the certificate or the reverse of the certificate that is to be given to the claimant. After stamping the certificate copy, the issuer company shall give the digitally signed copy of the letter of confirmation to the claimant by a registered speed post. After receiving the digitally signed letter of confirmation, the claimant shall submit the demat request within 120 days of the issue of letter of confirmation at the depository participant. The depository participant shall furnish demat request of the claimant and forward the request to the issuer company for opening the demat account. If the claimant does not process the demat request within 120 days of the issuance of a letter of confirmation, the securities will be credited into the suspense escrow demat account of the issuer company. Now we will discuss what documents are required for the transmission of shares. The documents that are required at the time of filing of the form are: in case of nomination and shares held singly, the documents required are signed transmission form from the nominee, original death certificate or copy of death certificate duly attested by the nominee, copy of the PAN card duly attested by the nominee. In case of no nomination and shares held singly, the following documents are required: signed transmission form from legal representative or heirs, original death certificate or copy of death certificate duly attested by legal representative or heirs, copy of PAN card duly attested by the legal representative or heirs. duly notarized affidavit signifying legal ownership, any other required documents. The other documents that are required for the transmission of shares are notarized indemnity bond along with a copy of will. In cases where a legal heir certificate is to be submitted, the said certificate shall be accompanied by a duly notarized indemnity bond, NOC from all legal heir who has relinquished their right. For more such update, please subscribe to the channel.